Okay, let's unpack this. We're looking at what feels like, well, a legal seismic shift today. Something that fundamentally changes how executive power gets checked in the US.
Absolutely. And what's really interesting, I think, is how a recent Supreme Court decision, which didn't come out of nowhere, it has roots in past actions, could genuinely reshape our understanding of human rights, our liberties. And it doesn't matter who's president.
Exactly. That's the core of our deep dive today, this June 2025 Supreme Court ruling. It puts new limits on something called nationwide injunctions. Now, the Trump administration, they pushed for this kind of limit. But the twist is, this could open up pathways for any future administration. Even a hypothetical President Harris may be implementing really sweeping policies.
Right.
And that leads to the big question we want to tackle. Could the very legal strategies people use to fight back against certain policies, could they actually backfire down the line?
Yeah, it's a complex dynamic. We've got some key excerpts from a piece, What If 6282025.txt, and also an image of Justice Sotomayor's dissent, which was quite powerful. Our goal here is really to pull out the most crucial bits, the important nuggets, to help understand this evolving legal picture.
So let's start with the basics. This June 2025 decision, what's the absolute core of it?
Okay, so the main thing is it restricts lower federal courts. They can't issue these nationwide injunctions quite like they used to.
And why is that such a big deal? Historically, these were used pretty effectively, weren't they? Like to quickly block controversial executive actions across the whole country. I remember the challenges to birthright citizenship being discussed.
Exactly. They were a fast-acting break. And this ruling lines up pretty clearly with what the Trump administration argued for. They saw these injunctions as, well, maybe overreach by individual judges. They framed it as needing to centralize power or at least stop lower courts from halting national policy so easily. Justice Kavanaugh's concurrence really supported that view. He saw it as kind of a necessary correction.
Okay, but then you have Justice Sotomayor's dissent. She warned about a new legal regime. That sounds serious. What's she getting at there?
Her concern, fundamentally, is about delay. Without that immediate nationwide stopgap, executive actions, even potentially unconstitutional ones, could go into effect and stay in effect for months, years maybe. Essentially, they could proceed unchecked while the legal challenges slowly work their way up through the courts, maybe through class actions or appeals. It creates this window where rights could be threatened without immediate, broad recourse.
So connecting the dots then, this ruling isn't just procedural, it genuinely creates a pathway, potentially, for any administration, Republican, Democrat, doesn't matter, to push policies that might erode rights.
I think that's a fair assessment, yes. It definitely opens a door.
Which leads to this idea of executive overreach, right? A policy, maybe a controversial gun ban or new immigration rules or, I don't know, even censorship measures. They could be implemented immediately before the courts have a chance to fully vet them on a national scale.
Precisely.
Yeah.
And think about that delay you mentioned, the time it takes for class action lawsuits to get certified, for appeals to be heard. That time lag is critical. It could mean temporary but very real violations. Imagine like temporary gun confiscations based on a new rule, or people being denied citizenship status, even if it's later overturned. The disruption happens before the final say.
So what's the impact on the judiciary itself? Does this shift the power upwards?
It definitely points towards judicial centralization. The Supreme Court effectively shores up its own power, becoming the primary body eventually to rule on the constitutionality of these nationwide policies. And that weakens the lower courts.
Yeah.
Their role as that immediate safeguard is diminished. It might even make an executive think, well, I can try this. I've got some time before the Supreme Court potentially stops me.
Okay, this is where it gets really counterintuitive for me. Could the legal tools used against certain policies, maybe those associated with the Trump years, actually end up harming causes people care about later?
It's a real possibility. Think about the reliance on class actions. They became a key tool for pushing back when nationwide injunctions were harder to get or challenge. But focusing on class actions, while necessary perhaps, normalizes a slower, more complex process. It takes time. And future administrations could potentially use that time strategically.
And that class action tool, it's neutral, isn't it? Anyone can use it if they have standing.
Exactly.
So a different administration could use that same slower class action process, maybe offensively, for policies like, say, mass surveillance or seizing property under some new controversial law. They could use the slowness to their advantage.
That's the potential downside, yes. What was a defensive shield could become an offensive tool. And related to that is this idea of erosion of precedent. This 2025 ruling didn't just tweak things, it overturned potentially a century of practice with nationwide injunctions. The stated goal might have been to stop judge shopping, finding a friendly court.
Yeah, I've heard that term.
But the effect might be to shield policies, any policies, from early, broad challenges. Even if there's strong local or regional opposition, the policy might roll out anyway.
So it's a bipartisan risk then. It's not about one party, it just potentially amplifies executive power, whoever holds the office.
Correct. A Democratic administration might use it for something like climate regulations or gun control, a Republican one for immigration or maybe deregulation. The mechanism benefits the executive branch itself.
And you have to think about public trust too, right? If people see rights being, temporarily trampled while the courts slowly deliberate.
That could definitely erode faith in the judicial system, especially if the process feels slow and unequal. It could easily fuel more polarization, more frustration.
Which brings us back to Sotomayor. Her quote was stark. "No right is safe in the new legal regime the court creates. Today, the threat is to birthright citizenship." But she wasn't just talking about that one issue, was she?
No, I think her point was much broader. She was using birthright citizenship as the immediate example, but warning that any right could become vulnerable in this period before the courts fully act. It's about the structural change.
Wow. Okay. This really forces you to think about the long game, doesn't it? You might feel like you're winning specific legal battles with the tools you have now, but are we, maybe without realizing it, weakening the overall structure, compromising the broader fight for liberty if this kind of shift in judicial power takes root?
It poses a really fundamental strategic question. Is the focus better placed on, short-term wins using the available tools, like fighting case by case through class actions? Or should the focus shift towards advocating for bigger, long-term structural fixes, things like new legislation from Congress, or maybe even, down the road, constitutional reforms to rebalance those checks and balances we've always kind of relied on?
That is definitely something to chew on. Thanks for walking us through this complex landscape.
Glad to be here. Some important stuff to consider.
Absolutely. Thanks for taking this deep dive with us.